Assalamualaikum and good day everyone. Today lectures cover part 2 of our course on the cultural environment of global markets, focusing specially on chapter 6 and 7, the political and legal environment. In this session, we will examine how political system, stability and legal frameworks influence international marketing operations. By end of this lecture, you should be able to analyze how political risks, government policies, and international legal systems shape global business strategies. The political and legal environment encompasses governmental activity, legislation, and regulations that directly affect marketing practices. For marketers, this environment is critical because political decisions, such as trade laws, taxation, or foreign investment policies, can either facilitate or constrain business operations. Therefore, firms must continuously monitor global political trends and legal developments to mitigate risks and adapt their strategies. Political environment can significantly influence market accessibility and profitability. Marketers must understand both the domestic political climate and the international political landscape, as both determine how firms operate abroad. For multinational companies, assessing political risk is not optional. It is a fundamental element of strategic decision making. In today's interconnected world economy, international political events have a profound effect on global marketing. A notable example is the impact of terrorism and geopolitical conflicts on industries such as travel, logistics, and international security. Another major trend is the global movement toward free trade and away from protectionism. Empirical evidence shows that countries practicing free trade tend to experience higher GDP growth and greater integration in global markets. This trend highlights the importance of economic liberalization and international cooperation for sustainable business growth. The stability of a nation's political system is one of the most visual determinants of business confidence. Political instability may arise from several causes: frequent change in a government, internal conflict, or extreme nationalism. For example, election cycles can cause temporary uncertainty in trade conditions or investment regulation. Nationalism may also lead to restrictive policies that prioritize domestic interests over foreign participation. Ideally, multinational corporations seek to operate in a stable and friendly political climate where policy remains predictable and conducive to international collaboration. Political risks refer to the potential for losses of adverse effects due to government action or political instability. Such risks include: first, confiscation, where a government seizes company assets without compensation. Second, expropriation, where private property is taken from public use, usually with some compensation. The third one, domestication, which involves transferring ownership or control to local entities. Beyond this, firms also face economic risks such as recession or inflation, and political sensation such as trade embargoes. Moreover, political and social activists, non-governmental organizations (NGO), violence, terrorism, and cybercrime further increase vulnerability. Understanding these risks helps firms design proactive strategies to protect their investment. To manage political risks, firms may adopt several strategic approaches. Joint ventures allow share ownership, reducing foreign dominance and increasing local acceptance. Second, expanding the investment base by involving local or regional investors foster political goodwill. And licensing and franchising limit direct investment exposure while maintaining market presence. Lastly, political bargaining enable companies to negotiate to favorable terms of incentive with host governments. Through this measure, firms enhance resilience and reduce the likelihood of conflict with authorities. Government often encourage foreign investment for economic and social benefits. Such encouragement may aim to accelerate national development, create local employment, facilitate technology transfer, generate export sales, stimulate the growth of domestic industry, and conserve foreign exchange reserve. When aligned when firms align their operation with those objectives, they can build mutually beneficial relationships with host nations. Now, let us shift our focus to the legal dimension of global marketing. Operating internationally required compliance with diverse legal systems, trade law, and intellectual property regulations. Understanding this difference is essential to avoid legal disputes and to conduct business ethically and effectively. The world legal system can generally be categorized into four main types. Common law, derived from English tradition, emphasizes judicial precedent and case interpretation. Code law, derived from Roman principle, relies on comprehensive written statute, can cover specific subjects. Islamic or Sharia law, based on the Quran, principle details social and economic behaviors. And last one, Marxist socialist law, influenced by socialist ideology, prioritize state ownership and economic planning, commonly found in Russia, China, and parts of Eastern Europe. Each system established different obligations for contract, property rights, and business operations, influencing how international marketers conduct transactions. In global business, legal dispute may arise between governments, company, or a company and a government. Determining jurisdiction, meaning which legal authority has the right to hear the case, is often complex. Jurisdiction may depend on clauses specific in the contract, the location where the contract was signed, or the place where its provisions were performed. Marketers must ensure that jurisdictional clauses are clearly defined to avoid costly litigation and uncertainty. When disputes occur, there are three common mechanisms. Conciliation or mediation, where a neutral third party helps the parties reach a mutual understanding. Second, arbitration, which is a private and less formal process where both sides agree to be bound by the arbitrator decision. And the third one, litigation, a formal process of resolving dispute through court proceedings. While litigation provides legal authority, it is often the most expensive and time-consuming method, making arbitration and conciliation more valuable in international contexts. Intellectual property rights, or IPR, represent a particularly critical issue in global marketing. These rights safeguard intangible assets such as patent, trademark, and copyrights. However, enforcement varies widely between countries and violations such as counterfeiting and piracy remain prevalent. Companies must register their intellectual property in each market and stay informed about local protection mechanisms to secure their innovation. The rest of e-commerce has introduced a new legal challenge collectively known as cyber law. Issues include domain name disputes, cybersquatting, internet taxation, and jurisdiction over online contracts. Since internet law remain regular and differ across countries, marketers must exercise caution in online transactions and ensure compliance with both national and international regulation. Commercial law regulates domestic marketing practices and includes several key components. Green marketing legislation, which enforce environmentally responsible marketing behavior. Antitrust laws, designed to prevent monopolies and promote fair competition, including those that apply to foreign companies. By understanding this law, marketers ensure ethical conduct, fair competition, and social responsibility in all markets they enter. In conclusion, the political and legal environment together define the operational boundaries for global marketers. Political stability, legal transparency, and effective risk management are essential to ensure sustainable international success. As future marketers, your role is not only adapt this environment, but to anticipate their change and align your strategy accordingly. Thank you for listening.